The House Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Here.
Representative Andrews.
Here.
Carter.
Here.
Breen. Young.
Here.
Arbit.
Here.
Devendorf.
Here.
Cerniglu.
Here.
Filler.
Yes.
Mueller.
Here.
Bazat.
Here.
Harris.
Here.
Begol.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you. Today I'm proposing a committee rule regarding testimony to clarify our procedures. You each should have a copy of the proposed rule at your seat. Representative Andrews moves to adopt the committee rule. Would the clerk please take the roll?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Here. Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
I apologize, Chair. I just started reading it, so I like where you're going. I'm going to pass for now, but I'm going to read this before I
So pass.
pass.
Representatives Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Begol.
Yes.
Madam Chair, you have 10 yeas, 0 nays, 2 pass. The motion prevails.
Thank you. And before we begin today, I'm going to issue a reminder that anyone who would like to speak to the committee, please fill out one of the white cards. There are some up here and there are some outside the room. And without further ado, we'll hear testimony on House Bill 4427. Here to testify in support as she makes her way down from the dais is Representative Stephanie Young. And please go ahead when you're ready.
All right, welcome. Good morning, Criminal Justice Committee, and thank you, Madam Chair, for having me today. It's an exciting day for me. I'm here to testify in support of my bill, House Bill 4277, which would allow incarcerated persons access to certain public records through Michigan's Freedom of Information Act, AKA FOIA. So you gotta ask yourself, how do we get here on today? And it started during my first term as a member of House Oversight, Chair Steve Johnson. And so we were taking testimony, we were hearing testimony during Sunshine Week, and it was testimony regarding this section of the law, and they were making some minor tweaks. But here's the thing that stood out to me during that testimony. During that testimony, it said, and let me get that just right, because I want to read it. It said, this act currently defines person as an individual, a corporation, a limited liability company, a partnership, a firm, an organization, an association, a governmental entity, or other legal entity. However, the term specifically excluded those incarcerated who had access to FOIA. And then I was like, wait a minute, the definition of a person actually excludes a person. How can that be? Something about that just didn't sit right with me. And so I immediately rose my hand in committee and said, excuse me, Mr. Chair, would you entertain an amendment to this? Perhaps we can put some guardrails around it. I understand that, you know, it's been thought that persons incarcerated have all the time in the world and all they want to do is just sit up and FOIA anything about anybody or any subject, and though that's really hasn't been proven to be so, but that can be the concern. And so what if we put some guardrails on it? Would you entertain a friendly amendment? And pretty swiftly, the chair, Steve Johnson, said no. And I got mad. I just got to tell you. I was like, what? And he said, wait a minute. I believe it needs to be a standalone bill. And if you do your research and if you draft it, I will guarantee you a hearing in House Oversight. And this is exactly what Chair Steve Johnson did. I did my research, and we drafted the legislation, and he became my first co-sponsor on the bill. We had a hearing, and it was voted out of House oversight unanimously. Why? Because it just simply made sense. And so, when we look at what we're dealing with today, currently, Michigan is one of 15 states that expressly deny an incarcerated person an opportunity to utilize FOIA for their own records. This essentially means that incarcerated individuals cannot request or receive important documents, including police records, court records, or other publicly available information related to their own cases or the cases of their children. I ask members, and this is a rhetorical question, of course, but how can someone properly participate in their own defense if they cannot access necessary documents related to their own case? And let me just clarify, these are, again, public documents. That means that they have access to them, but it's through a third party. So what I've heard during my time of working on this is someone will get incarcerated, and they can be there, and family will be with you for the first year, and family and friends will be with you for the second and the third and the fifth year, and they'll do all of that research for you. But then there comes a time when people get back to their regular lives, and not that they don't care and not that they don't love you, but they just don't have the time anymore to invest in doing all of this work when the person who actually has the time is limited in the ability to do it. And so in recent research, there's a recent research article titled "Academics Find Prisoners Deny Access to Public Records." It was published in October of 2023, and the authors state, when governments attempt to limit prisoner access to public records, they generally claim a poverty of resources to fulfill the request. But this justification for singling out those behind bars simply amounts to they just file a bunch of public requests as if prisoners are bored and with a lot of time on their hands to file public records just to aggravate government officials, especially those they feel are responsible for their incarceration. But again, to aggravate or to potentially prove your innocence, is that something that shouldn't be considered? I believe that we need to consider the opportunity for those who are behind bars to be able to participate in their own defense. The perception of FOIA requests from incarcerated persons is just a nuisance and waste of time is, in my opinion, offensive, particularly, again, for those who have sat behind bars, sometimes for decades, for crimes that they simply did not commit. In fact, the current restrictions put further pressures on families to pay for attorneys and outside sources to get the needed records for their loved ones. There are a number of stories right here in our state and recently in the news about individuals who have been wrongly convicted and later exonerated. In some cases, exoneration was due to being able to prove their innocence when errors, bias, and other evidence was withheld in the course of presenting their defense through records obtained through FOIA. I want to be clear. My bill is important to amend the current law to allow FOIA access to incarcerated persons in very specific ways. This bill restores only the right to access public information that is not exempt from disclosure under FOIA. It only includes information that is public information that pertains to an inmate's own case or to a case involving a minor child for whom the inmate retains parenting time privileges. The H-2 substitute also adds cases where the incarcerated individual or the incarcerated individual's minor are the victims. To be clear, my bill protects minors in that those who had their parental rights terminated or parenting time suspended would not be able to access the child's case information. In addition, my bill provides a correctional institution up to 30 days, that's right, 30 days instead of 5, to respond to a FOIA request from an inmate, hopefully allowing adequate staffing and time to copy and transmit the information to the requester. And hopefully, this time frame in the bill will alleviate concerns that public agencies, including jails and prisons, would be overburdened by request. Before the 1994 law that banned inmate requests, prisoners in Michigan were allowed to make these requests. Again, not having the right to obtain public records is particularly burdensome to individuals who are wrongly convicted or who may have grounds to appeal their case or length of their sentences. In my opinion, this is just quite simply common sense legislation. It is an example of caring about people and putting all people first and giving real chances to incarcerated individuals to make certain that they have true appeal rights as well as other post-conviction rights. This is one step to make our current system more just. It is a matter of fundamental fairness. With that, Madam Chair, I say thank you to you and to the committee, and I encourage your support.
Thank you. I'm looking for questions for Representative Young. We don't. We have a number of folks who are coming to testify in support as well. Representative Harris, you snuck one in on me.
Thank you, Madam Chair. Thank you, Representative Young, for being here. So, after my law enforcement career, I actually went into PI work. And we did some work for groups like the Innocence Project and whatnot, and some other indigent defense groups. And so many times we acted as that third party to obtain FOIA requests. So just knowing there is some burden, but there's also some steps that people have to go through in general to get FOIA. Who would pay for the FOIA documents? Mm-hmm. So if there's a charge there, whether it's for, say, like a DVD or for, a substantial amount of paperwork, who would cover that expense?
Yeah. Currently, the inmate pays for it, so we're not changing the cost. We're just making it available firsthand, opposed to going through the third party. But whatever the cost currently exists, those costs will still exist.
Okay, thank you.
You're welcome, thank you.
Representative Bagul.
Thank you, Madam Chair. Thank you, Representative. Can you explain to me a little bit more about the correction agency being included in this, and what records specifically would be included? Like, would this be something they can FOIA, like disciplinary records that may contain information on other inmates or anything like in regards to that?
Okay, so this is very narrowly tailored to allow an incarcerated person access to their case files. So it has to do with them and them only. If it does not include, say, they want to FOIA us, or they want to FOIA, well, what happened with my cellmate's case? They can't do that. It's strictly relating to their case only, and information regarding their minor child. What I found during my research and talking to people who have experienced this, what I call injustice, is they've never had their parental rights terminated. They have an opportunity to see their children, but for whatever the reason, they haven't been able to get information regarding their children. What I want to also be very clear about is the information that they'll have access to is information they already have access to. We're not saying they can get any additional information. The key is, instead of having to go through a third party, they can access it themselves, but only regarding their own cases and those of their minor children.
If I could just a follow-up question, I'm still not clear. So if the correction agency is included in the FOIA, what specific information are they able to FOIA from the correction? So disciplinary records, or only specific to the case that got them incarcerated?
Okay, and with that, I may even yield to Kyle Kaminsky here, because right now, whatever they can request, and I'm not exactly sure just how much they can, because I don't think they can get their disciplinary, because that happened after incarceration. Mine deals with what leads up to the incarceration.
Right, and that's my concern too, that
Yes.
maybe they might be targeting other inmates to
No,
find
that's
out
correct. It leads
information or something like that.
It's what got them there. That makes sense, Representative?
Yes, if that's the answer.
Okay, all right,
Thank you.
that's the answer.
Representative Bazat.
Thank you, Madam Chair. Thank you, Rep. Young, for being here today. Just curious if you've been working with stakeholders, the townships, counties, prosecutor's office, any input from them on how they stand on the issue?
Yeah, we reached out to a number of stakeholders. You'll have a list of supporters. There are a number of people in the room. I can do some additional work with the prosecutors, but I hadn't heard that they opposed the legislation. Thank you for asking.
Thank you, Representative Young. We're going to move on to some other testifiers here. I looked that word up, and it is a word. We have Ken Nixon, who's Director of Outreach and Community Partnerships at Safe and Just Michigan and President and co-founder of the Organization of Exonerees. He's on Zoom. Good morning, Mr. Nixon. Go ahead when you're ready.
Good morning, everybody. Thank you, Chair. Thank you, Rep. Young, for introducing this bill. To kind of circle back to Rep. Young's closing, her very last statement was, "It is a matter of fundamental fairness." And honestly, I want to repurpose that statement and say it is a matter of life and death for some inmates. My backstory is that I'm an exoneree. I spent almost 16 years incarcerated in the Michigan Department of Corrections for a crime that I did not commit. My innocence was eventually discovered sitting in a box somewhere in a Detroit warehouse. The officers involved in the investigation of my case knew within hours of my arrest that they had arrested the wrong person, and they continued to push the investigation and eventually prosecute me and send me to prison for 2 natural life sentences plus 40 to 60 years. What we discovered in those FOIA requests that were done by third parties was that within hours of my arrest, the investigating officers were exchanging memorandums and emails between themselves about how they had arrested the wrong person. And they knew they had arrested the wrong person. And for 16 years, I had no access to those records. It would eventually be journalism students and the Thomas Cooley Innocence Project working in tandem with the Wayne County Prosecutor's Office Conviction Integrity Unit that discovered those records. The purpose and point of legislation like this is, without it, there's a very high likelihood that I could have died in prison. And multiple government authorities knew that I was innocent. And there was nothing I can do about it. I had no access and no way to access those records without the assistance of a third party. Fortunately for me, I had the resources and the mental capacity, the fortitude to be able to advocate for myself and get those organizations on board to help me. There are a lot of people still in Michigan Department of Corrections that do not have that same access or ability or resources to access those third parties that are willing and able to cover those expenses when it comes to FOIA requests. This legislation is absolutely necessary. That Brady violation that was discovered a decade and a half later took something from me that no one can give me back. That time that I lost could never be restored. There's not enough money in the world to cover those Christmases and birthdays that I missed with my kids. All of this could have been avoided had I had access to the records that eventually sent me to prison. Thank you.
Thank you. Any questions for Mr. Nixon? Thank you for your testimony. We'll move on to Daryl Siggers. I hope I pronounced your name correctly. And he's also on Zoom. Good morning. You can go ahead and get started when you're ready. You may be muted, sir.
Okay. I'd like to thank the chair, committee members, and Rep. Young for presenting this very important bill, as well as my fellow exoneree, Ken Nixon. I want to first state that this bill is very important for many of the reasons that Mr. Nixon indicated, as well as Rep. Young. I am exonerated. I served 34 years in prison for a crime I did not commit. And in the 30th year, I submitted a FOIA request through a doctor, and I was able to obtain police reports that showed that the so-called forensic examiner in my case, or the firearm examiner in my case, gave just essentially just false testimony in terms of what the evidence actually showed. Once I got these records, I was able to present this to my legal team, and I had to get this again through a third party, through a doctor, and again, 30 years later. I was able to get these records, share them with my legal team, and they presented these to the Conviction Integrity Unit, which subsequently exonerated me, dismissed my case, found out that I was innocent just based on these records, which led to a lot of other information. Many individuals inside are not able to obtain these records because, as Mr. Nixon has indicated, they don't have people on the outside that will assist them. And so, because it's limited now, I remember back in 1994, prior to, there were individuals who were abusing this process, but that abuse element or the ability to do that has been eliminated because it is now narrowed down to records that are specifically regarding the individual's case, his prosecution, and or their young minor children. And so the ability to abuse this process is gone. And so in a matter of, in the interest of transparency, which we talk about in our government and our society, I think it's necessary to restore inmates the ability to directly file Freedom of Information Act requests. And to answer that committee member's question about if a FOIA request could be submitted to an institution, it will be submitted for their institutional file. And there's no records in there that would be exempt. And this will be necessary because an individual may be going back to court for resentencing. And so he needs a copy of all his reports, his information, his certificates, his what he's achieved, his academic background, all of this stuff so he can present to a judge or a pre-sentence investigator in support of his request for resentencing. There are many individuals inside, again, who do not have access to these records, who may very well die in prison because they cannot get access to their records. And let me just say, right now, I created a company, and what our company does is individuals pay me to file Freedom of Information Act requests for them. And it's not an easy process. So they pay me to do this stuff. And so if y'all were to grant this, it would run me out of business. And I'm okay with that because I want individuals to have access to their own information, and they should have access to their own information so that they can protect their own constitutional rights. Many times, and I know many of the committee members have heard about all the exonerees that are being released. Most of them are 90% of them are being released just based on information that they got out of their own prosecutor's file, police file, or court file. And as Mr. Nixon has indicated, the 34 years that's been taken from me can never be given back. Lost my mother, my father, half my whole family. Had I had this information at the time of my first appeal, I would have not served 34 years. So again, thank the committee members, thank Rep. Young, thank the chair, thank you all. And I yield back to the chair. Thank you.
Thank you. Questions? Representative Young has a question for you, sir.
Thank you so much for being here and providing your testimony. I know you just said that you started a business to help those who are trying to obtain their records, and you just said that, you know what, it's worth going out of business to be certain that something like this passes. I don't think you will, because you also said that not everybody has the capacity to do it. And so I'm just, I think that's powerful. I don't want that point missed here in committee, is that you see this being a necessity for people, and you're willing to put your own business at risk. I'm certain we heard that right. Could you just elaborate on that just a little bit more, Mr. Sickers?
Well, I filed individuals right now, they'll write me and say, hey, can you do a Freedom of Information Act request for me? because I can't do it. So I'll do it. And it's not an easy process. You have to know specifically what you're doing and able to get this information. And then so far as this overwhelming the system, inmates pay for this stuff, and they require you to pay for their time. They require them to search for this information, download this information, and to send you this information. So you have to pay the postage, you have to pay everything. So it ain't like this is nothing free that this bill would be providing us. You still have to pay for their time and so forth. And so for me, individuals, it has taken me a long time to learn this process. But for me, it has become routine to do these things, guys. And so if you guys would pay this, pass this bill, and I hope that you will, it would essentially put me out of business. But again, I do this every day. Guys are writing me, families are writing me to do this work because they understand the importance of it. When individuals learn that I got out, basically, for the most part, as a result of obtaining documents that proved that the police in my case had fabricated evidence, it has become widely known throughout the system. And now a lot of guys are trying to file Freedom of Information Act requests through me. I'm overwhelmed. I can't even do most of the requests that these individuals are asking because I'm just one person. And so it would be tremendously helpful if this committee would approve this bill. It's not going to add any more work to the people who's already doing the work because they're being paid to do it. And it provides a sense of fundamental fairness, transparency, and it's in the best interest of us all. None of you guys, none of you folks, you good folks on this committee, want individuals serving sentences that they're not guilty of. And this would help in transparency and revealing what an inmate should know. And if there's any information or sculpture information in his file, he should have access to it. Thank you.
Thank you. Thank you for your testimony. Next on my list is Chuck Warpahosky, Project Director for the Michigan Collaborative to End Mass Incarceration. There he is. Good morning. And when you get a chance, or you don't have to do it right this minute, but if you could fill out a white card to make sure that your information is recorded accurately in the minutes.
Thank you. Will do. Good morning, Chair Hope, members of the committee, Representative Young. Thank you for the chance to share the support of Michigan Collaborative to End Mass Incarceration for this bill this morning. Michigan Collaborative to End Mass Incarceration, or MISEMI, is a network of organizations across the state, advocacy organizations, human service providers, faith groups, business, and others who are united on trying to look for ways that we can reduce the size of our prison population while improving public safety through effective prevention, reducing excessive sentences, adequate provision of rehabilitative programming while people are incarcerated, and strong reentry systems so that after somebody returns home from a term in prison, they're able to restore their lives and stay out of trouble. Our members support this legislation and are grateful for the chance to speak today. As the speakers, especially the members of the organization exonerees, the exonerated people who spoke before, it is important that people have access to their own court records and case records, whether or not they're incarcerated, so that they can pursue their case if there's an innocence claim or other concerns. And as the speakers showed, this is the people who are falsely incarcerated have a stake in this, but we all have a stake. Right? When Mr. Nixon was falsely imprisoned for the actions that he was imprisoned for, that means the person who did commit the crime wasn't caught. Right? So that undermines all of our public safety. We all have a stake in making sure that people can pursue a false imprisonment case for all of our safety and for the integrity of our own court and criminal legal system. Right? If people can't have access to their own files to pursue their cases, it undermines their ability to, the whole trust in the court system, the criminal legal system is undermined. This is something we all have a stake in. And I'm grateful for the work that our Representative Young and others have done to bring this policy forward. Furthermore, in addition to the public policy issues, for our members, we see there's a matter of principle in this. Under the current FOIA rules that this bill would amend, under the current FOIA rules, if you are a corporation, you're a person. I get that through legal person. I get that. But if you're incarcerated, if you're an incarcerated person under the current FOIA legislation, you're not a person anymore. And that that principle framework is a concern for everybody, I think, in our democracy. You know, for me, as a person of faith, I think back, Paul and Silas, when they were in jail, they were still people. In our own democracy, when Martin Luther King was in prison, he was still a person. And regardless of what you think of their actions, the January 6th participants who are incarcerated, they are still people too. And they should have access to the records and documents that are relevant to their cases to pursue their own legal defense as people, as citizens in our country. And so I really respect and appreciate the hard work that Representative Young did to find a compromise situation that has guardrails that everybody can get on board with. This is a very modest and thoughtful process. From our membership, most of our members think it should go further. We believe that as a person, people they still have a stake in what's happening in their government and should have full FOIA access, not the limited. And that our members believe that people shouldn't have to pay for their own files. I understand the concern that was brought regarding the cost of FOIA. I've been subject to FOIA. I know what you go through. But this is a compromise. This is a first step, and it's the most important one to make sure that people who are incarcerated are recognized that they're still people and have access to the documentation necessary to pursue their innocence claims, to stay connected with their family, and to move forward with their lives. Thank you.
Thank you, sir. I don't see any questions. Appreciate your testimony. Next, we'll have Amanda Walwin, State Policy Advocate from the Innocence Project, who's on Zoom. And I'm also going to ask Mark Hartman, who's Executive Director of Humanity for Prisoners, if he wouldn't mind coming to the table as well. Oh, I'm sorry. I misspoke. Mark, you can stay where you are. Go ahead, Amanda.
Great. Thank you so much. My name is Amanda Walwin, and I'm a state policy advocate with the Innocence Project. The Innocence Project is a national organization that represents wrongfully convicted clients across the country. We also work to enact state-level policy reforms that prevent and reveal wrongful convictions. Our cases vary widely, but there is one thing they all have in common. Reinvestigating an innocence case requires information from the underlying case. In most cases, the first step for our attorneys is to request our clients' case files, whether that's through discovery, FOIA, or directly from a prosecutor. Without that information, there's simply no way to make informed decisions about how to pursue an innocence claim. In Michigan, 71 of the 173 exonerations involve Brady violations, that is, exculpatory evidence that was withheld from the defense. Those 71 exonerees could never have demonstrated their innocence without access to their case files, including that exculpatory evidence. For incarcerated people who aren't represented by counsel, the only way to receive their case file is through using the Freedom of Information Act. However, Michigan law currently expressly prohibits incarcerated people from filing requests under FOIA. This leaves those people without an avenue to be able to see their case file, to understand the details in their case, and often to be able to convince an attorney that they have a viable innocence claim. I also want to flag the stories that Mr. Nixon and Mr. Siggers have shared with us today. It's important to note that their stories are success stories, and they served 16 and 34 years in prison, respectively. For each Mr. Nixon, for each Mr. Siggers, there are so many others who can't access their case file, who can't reveal their innocence, and who are still wrongfully incarcerated. House Bill 4427 is a narrowly tailored bill that will allow people who are incarcerated to access only their case files or their children's case files through FOIA requests. The Innocence Project supports this bill, and we applaud Rep. Stephanie Young for introducing this important legislation. Thank you for the opportunity to testify.
Thank you for your testimony. I don't see any questions, so we'll keep moving here. Now, Mark Hartman and Susie Greenbauer from Humanity for Prisoners can come on up. Apologize for my confusion. And go ahead and get started whenever you're ready.
Good morning, Chair Hope, Representatives Young and Filler, and esteemed members of the Criminal Justice Committee. Thank you for this opportunity to offer supporting testimony for House Bill 4427, an amendment to Michigan's Freedom of Information Act law of 1994. My name is Mark Hartman. I serve as the Executive Director and President of Innocent, doing business as Humanity for Prisoners. Today I'm joined by fellow team member at Humanity for Prisoners, Susie Greenbauer. Humanity for Prisoners is a 501c3 nonprofit organization based in Grand Haven, Michigan. We have a proud 23-year history of advocacy for Michigan's incarcerated. In fact, our team serves more than 10,000 clients housed in correctional institutions across the state of Michigan, nearly 1/3 of the state's incarcerated population. Today, I testify not only as the leader of this organization, but also as a former client of Humanity for Prisoners. The significance of this moment is very personal for me, personally. 15 years ago today, I was sentenced in the Berrien County Trial Court to serve consecutive sentences totaling 12 to 30 years in the Michigan Department of Corrections. Michigan Department of Corrections. I served 12 years at state prisons in Jackson, Muskegon, and Ionia, and I was released in 2020. Speaking as a former HFP client, I can personally attest to the difficulties encountered by incarcerated men and women attempting to access public records in their own name or in the names of their minor children. I've lived this experience. It's frustrating. At Humanity for Prisoners, we work with incarcerated clients each and every day. As a third party, we have also filed hundreds, if not thousands, of FOIA requests over several years on behalf of incarcerated persons, precluded by law from requesting access to their own public records or those of their minor children. For example, I'll cite a few figures. FOIA requests initiated by Humanity for Prisoners on behalf of incarcerated clients by year are as follows. In 2019, we filed 196 requests. In 2020, we filed 189 requests. In 2021, we filed 391 requests, more than double the previous year. And in 2022, we filed 286 requests. Humanity for Prisoners stands firmly in support of House Bill 4427. We believe its legislative sponsors are taking steps in the right direction. While some would suggest the bill does not go far enough, on the contrary, we see this proposed legislation as a positive step forward. This is a move in the right direction. It is about fairness, and it is simply the right thing to do. Our support for House Bill 4427 notwithstanding, we do perceive a few legitimate concerns. One, first of all, is how might the bill's final language ensure that incarcerated persons actually receive their requested public records? Second, as a practical matter, would the bill designate FOIA responses as special handling within the Michigan Department of Corrections? Given the complexity of MDOC institutional mail policies, we strongly recommend FOIA responses to future public record requests be treated as legal mail. Third, the reconstruction of lost legal files, including public records, due to interfacility Michigan Department of Corrections transfers should be addressed. Nonetheless, Humanity for Prisoners is greatly encouraged by the progress House Bill 4427 would represent for Michigan's incarcerated. And in conclusion, I want to thank the Criminal Justice Committee once again for the opportunity to testify in support of HB 4427 today. And at this time, I welcome any questions the committee may have.
I don't see any questions. Thank you for your testimony.
Thank you.
Okay, now Kyle Kaminsky has graciously agreed to come up and answer some member questions, and feel free to respond or elaborate on anything you've heard so far. Filler? Representative Filler has a question for you.
Thanks, Kyle. Good to see you. I guess my question would be,
I see what's trying to be done here. I completely understand it. I do have some questions about the actual carrying out of how it happens because of the complexity of mailing in and out of prisons, and also how would an individual know what happens to their FOIA request. I realize we're doing a 30-day, I believe, a 30-day to respond. Is that right? And how, if that 30-day is not taken care of or is taken care of, how would we know one way or the other? Because I can imagine a situation where someone would say, well, I didn't hear, and so then I'm going to file, my FOIA rights were violated, but they actually weren't. It just got lost in translation. So I'm really interested in what it looks like as we carry this out, and I'm hoping you can sort of shed some light on that.
Thank you very much, Madam Chairwoman and members of the committee. Kyle Kaminsky from the Michigan Department of Corrections. I think those are great questions. We have been working with the sponsor on this legislation for some time, and I think we understand the intent of the language and do not have concerns about that intent. I think you heard a lot of compelling testimony today as to what drives this. But to your question, Representative Filler, I do think that's where some of the challenges will lie if this is implemented. Realistically, incarcerated individuals making FOIA requests are going to have to do so in writing because that's the means that they will have to make those requests. So they will use U.S. mail and mail out to the agency or entity that has the documents that they think are responsive to their request. At that point, the ball would kind of be in the court of that agency or entity to do the response, find the responsive documents. The challenge, though, will be that there is a cost for most FOIAs. So that cost is not known at the time that you submit your request. So there'll actually have to be sort of a back and forth interplay between the possible document holder and the document requester. For folks who have access to the internet, that's a little easier because of email, but that will likely have to be done through U.S. mail in these situations. So that may delay the process a little bit. As far as people's rights to appeal, obviously if they don't receive that document in the timelines laid out in the statute, they would have a right to appeal that. We will try to process mail as quickly as we can, but ultimately I don't think there's a way for us to guarantee or take obligation for that timeline. It really is a relationship between the requester and the agency that has the requested documents. No different than the U.S. Postal Service also has a handling time for those documents. So I do think there are going to be some practical challenges that we will all have to work through post-implementation of a bill like this. But I think we've worked really constructively with the sponsor and certainly understand the intent of what's trying to be achieved.
Representative Young.
Thank you, Madam Chair. Mr. Kaminsky, could you explain to us the current process, how the incarcerated persons utilize FOIA through third party right now? What does that look like?
So I think in most cases they are would either be using U.S. mail or they'd be using JPay, which is the electronic email system that is available to incarcerated individuals. They can buy electronic stamps. The challenge is that most of these outside entities, like a government entity that would have the documents, is not utilizing JPay. So there's not a way to have that communication, whereas the service provider in these cases, or the advocate, they're using JPay. So that probably speeds it up a little bit because they have that electronic means of doing that. But short of requesting that all of these outside entities utilize JPay, which is unrealistic, I think U.S. mail would have to be the primary route. Yeah, today I'm sure there are. Yep, absolutely. So it is not a new concept, and quite honestly, we have members of the public who make FOIA requests of us through a number of different means, including U.S. mail.
Representative Bazat.
Thank you, Madam Chair. Thanks for your testimony. Kind of curious, if there's a violation of FOIA, there's a remedy for that. There's a process. What court system would handle it? Has that been worked out, or do we know what that looks like?
I don't know that has been directly discussed. I think it would be somewhat dependent on who the agency or the entity holding the documents would be. I think if it was a state entity, it would probably actually be a court of claims challenge. I think if it was a local entity, I think it would most likely be in the circuit where that entity is located, not the circuit where the incarcerated individual is located, but would need to double check that.
Thank you very much. I have a few cards to read in here. Tony Gant from Nation Outside supports the bill, does not wish to speak. John Cooper from Safe and Just Michigan supports the bill, does not wish to speak. Noah Smith, Criminal Defense Attorneys of Michigan, supports the bill, does not wish to speak. Marla Mitchell-Sisson from the Cooley Innocence Project supports, does not wish to speak. Elizabeth Cole from the University of Michigan Innocence Clinic supports the bill, does not wish to speak. ACLU of Michigan supports the bill, does not wish to speak. The Michigan chapter of Citizens United for the Rehabilitation of Errants supports HB 4427, does not wish to speak. Michigan League for Public Policy supports the bill, does not wish to speak. Citizens for Prison Reform support the bill, do not wish to speak. I neglected to ask for a motion to adopt our minutes from February 13th. I'll take a motion from Representative Breen, Without objection, the minutes are adopted. We do not have any absent members. So there being no further business before the committee will stand adjourned.
Thanks, Chair.